Good evening, folks. I want to thank you for inviting me into your home tonight to talk to you about an extremely important issue to you. I'm basically here to talk about the United States Constitution and our government, and some of the principles thereof. You need to understand most thoroughly so that you can have an effective opportunity to exercise your constitutional rights. The whole purpose of this is that you understand that these rights come from God. They are God-inspired. God is the one who endowed you with these rights, and the Constitution merely offers a legitimate program to protect those rights or to secure those rights and the blessings of those rights for ourselves and on our children for all times. It is important that you understand that the Constitution God inspired. It is important that you understand that a lot of the principles that are in the Constitution actually come out of the Holy Bible. And it is very important that you understand that this Constitution allows you each to be a king or queen in your own right, as long as you recognize one principle that you don't ever create a situation where you take away the rights of another. So the 4. whole point of having the Constitution is so that all of us can have these rights equally. As long as we respect our neighbor and allow them also to have the rights equally, the protections are going to last forever. And the reality is that we are going to get thoroughly into your Constitution. And we want you to find a Constitution wherever you can. And we are basically going to take you step by step through some of the most important parts of this Constitution so that you can better exercise your rights in a timely fashion. Now the facts are simple. If you don't know your rights, you don't have any rights. We have come a long way with this program to help you. The most important thing I can teach you about this Constitution is the importance of reading it. You must read the Constitution and understand what physically is involved. You must know your rights and timely assert them. That is your burden. If you do not, then a legal term called laches incurs in full force. Laches is a species of action wherein a party of reasonable intelligence and integrity, having a right to take an action as prescribed by law, and having failed to timely do so loses all right to proceed. Basically, there is an argument. If I violate your rights, you may or may not know about it. If you do know about it, you may or may not be able to do something about it. And if you do have the ability to do something about it, you may or may not have the financial wherewithal to go to a finished program. If you do have the financial wherewithal, you may not have the intestinal fortitude to go to the finished program. So most of the time your governments, and your abusive personalities in government, or you corporations, pretty much have carte blanche to injure you. Because in 99% of the cases, most people will not proceed. But every now and then you run into that one hard nut, and he or she doesn't quit until the cows come home. What happens is that person will prevail, and those are the people who are actually generating better protections and better constitutional rights for you. Those are the ones who are going to the Supreme Courts and courts of appeals that are pushing, that are spending their life funds to allow you to have the benefit. But if you aren't there to catch the benefit, then the benefit is lost. The Constitution. It is important that you understand that the Constitution is in writing. It is important that you understand that it is a legal document, that it was ratified by all of the members in Congress together, and that document has all the signatures on the document. And it is important that you understand that there was an offer. The government offered to govern. There was a consideration. The citizens considered how they were to be governed, and government promised that they would govern by Constitution, and there was an agreement. 5. Citizens agreed that if government promised that there would be government by Constitution, they would allow the Constitution into force. Now there is a unique situation in force here. It is very rare when you find the party of the first part, which is the congressmen, officers of the government, who are also parties of the second part as representatives of we, the people of the Republic. When they signed the document, they signed as officers of the government agreeing to the Constitution, and simultaneously as officers and representatives of the people in the Republican form of government. When they signed that document that constituted an ironclad contract in writing enforceable in a court of law, pursuant to the statute of frauds. Now all we ask is that they enforce the contract. If we read something in the Constitution, and we have a good reason to believe it is the way it is, then they should honor that. And they should honor it in favor of you, the clearly intended and expressly designated beneficiary. The first thing you need to understand is Article 6, Paragraph 2 of the Constitution. This is known as the Supremacy Clause of the Constitution. Basically, what it says is, this Constitution, and the laws of the United States which shall be made pursuance thereof, and the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. The judges in every state shall be bound thereby. Anything in the Constitution, or laws of any state to the contrary, are notwithstanding in law. First important case, Marbury v. Madison, 5 U.S. 137, 1803. This is one of the leading cases in the history of the U.S. The opinion of the court was, anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme was illogical. For certainly, the supreme law would prevail over any other law, and certainly our forefathers had intended that the supreme law would be the basis for all laws, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as though it had never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded by a court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a mere nullity or a fiction of law, which means it doesn't exist in law. Now let me give you an example in today's timing as to how effective this is. This argument is so effective that it literally nullifies the Brady Bill. It nullifies the crime bill that takes away the right of the people to keep and bear arms on these 19 weapons that turn into 159 weapons. It stops the 666 bill that just went through that they trying to take away the Fourth Amendment. Because they have no 6. Power to pass a law that is in conflict with the United States Constitution, and it is automatically null and void of law from its inception, not from the day you go to court and brand it as unconstitutional. A lot of people think they have got to go to court and brand it unconstitutional, but if you know your arguments and you can show your arguments, most of the time you will win. Every now and then you will run into a hard nose, but I will show you how to deal with him, too. The next thing I am going to teach you is about the Second Amendment. The Second Amendment is the one everybody talks about today, and the one that probably gets railroaded the most. The next is the Fourth Amendment and the Fifth Amendment. The Second Amendment is one of the most vital amendments here because our forefathers had such an important understanding of life, liberty, and the pursuit of happiness. That was the First Amendment. That they turned around and realized that without the right to protect that first right, they didn't have that right. So the Second Amendment, they instituted the right of the people to keep and carry arms, and that right shall not be infringed. Now they started out by saying, a well-regulated militia being necessary for the maintenance of a free state. Now that is a true statement. But the most important part about that Second Amendment is where it says, the right of the people. And the Supreme Court has ruled in hundreds of cases that whenever it says, the right of the people, it means the right each, of every single citizen to possess the right equally. Now a lot of guys like to hand out this Minloa. Well, that is a collective right, you have got to be a member of the militia. That is all BS, you don't have to be a member of the militia. All you have to do is be an American. You have the right. The right to keep and carry arms, and that right shall not be infringed. Now note after infringed, there is no subparagraph of B, C, D, E, which would stipulate what would be an acceptable infringement. So all infringement is forbidden. I ask them, what is it that you don't understand about the word infringement? Because that is what it says when you look it up in Black's Law Dictionary. When you want to talk to these people in court, you want to have Black's Law Dictionary. You would be absolutely amazed what is in Black's Law Dictionary. These are the exact words that you need to be able to definitively define the work game problem we are having with these people today. They keep changing the words. But guess what? The words in this book are the words that were written when we were in the Constitution when it was signed. And the definitions that are in this book are enforceable in a court of law. You can bring this book into court and pull it open and say, this is the one, Judge, and they have to listen. And that is the way it is. 7. So, for sure, if you are going to be in this, Go down to a bookstore or Amazon. Come and get a copy of Black's Law Dictionary. You need that to be in this because it's like defining the map of how to get from A to B. You have to have this book so you can pull it out and say, hey, Don T. Trample my rights. Another good book on the Constitution you can pick up is The American Constitution, put out by West Publishing. This goes into a whole lot of widened arguments as to your Constitution. Now after I am finished talking to you, you're going to have a new concept of the Constitution and how it works. You're going to understand that it's what you say it is. If you have got an honest right. I'll give you an example. Now the First Amendment basically talks about the right of life, liberty, and the pursuit of happiness. But isn't the right to work part of the right to life, liberty, and the pursuit of happiness? You've got a right to work, right? To contract your labor, your skill, and your time and life as you see fit, right? That's a First Amendment right. Another First Amendment right would be the right to travel freely and unencumbered. No state can require you to have a license to travel freely and unencumbered, and we will go into that and show you how that is taken care of. The bottom line is you need to learn as much as you absolutely possibly can in the shortest possible time about your Constitution, because I am telling you right now as we speak they're trying to curtail that Constitution and take away rights that you have been given to you by your forefathers. There's only two things that are going to stop that. The first thing is that if we all get together, get a hold of the Constitution and start shaking it. Whoa, horsey, we're not letting you take away that Constitution. This is America. We've got an American flag on the pole out front. Last time I checked, this is America, and we have got a Constitution here, and you ain't touching that Constitution. The second way we can do it is if necessary and proper, our armed militia can come together and decide to tell these people that are giving aid and comfort to the enemies of our country, by breaking our laws, that you have broken the law of Title 18 U.S. Code Section 2381, which says, when in the presence of two witnesses to the same overt act, or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States, and honor your oath of office, you are subject to the charge of capital felony treason, and upon conviction, you will be taken by the posse to the nearest busy intersection, and at high noon hung by the neck until dead. The body to remain in state, till dusk, as an example to anyone who takes his oath of office lightly. You see, without that oath of office, this Constitution is worthless. That's why we have you take that oath of office, so we know that you will honor that oath of office. 8. And that you will keep our Constitution. The bottom line here is that you have to know to be able to exercise your Constitution. The most important part of your Constitution are in the first 10 amendments. Obviously, the right of the people to keep and carry arms shall not be infringed. And that right shall not be infringed. You must claim your right if you want to have it. You have to be willing to do that. And if they're going to take your right, then you have to be willing to challenge them whatever the cost. The bottom line is that any law that comes in conflict with that, what do we talk about in Article 6, Paragraph 2? If any law should come in conflict with the supreme law, it is null and void of law. It bears no power to enforce, no obligation to obey, and it purports to settle as if it never existed. The unconstitutionality dates from the enactment of such law. If any portion of a bill is unconstitutional, the entire bill is unconstitutional. Why? Repugnancy. It is repugnant to the Constitution. Now, other cases involved are your rights to due process. Like under your 4th, 5th, and 6th Amendments. The right of people to be secure in their houses, person, papers, and effects against unreasonable search and seizure shall not be violated. No warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Obviously, that would imply that he'd gone before a judge and said, this is the guy, he did it, this was the crime, and this is the evidence we are looking for, Judge. We like to get a warrant, and we swear that what we told you is the God's truth. Then they can come over and search until hell freezes over. Now it's important to jump to the 9th Amendment. Enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This means Congress has no authority to add on to the Constitution in such a way that would take away rights previously guaranteed. 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it are reserved to the states respectively or to the people. The Constitution is a contract designed to limit government. When you get into your police powers, you start understanding your police powers. You will hear this all the time. Well, we have police powers, broad and sweeping police powers. Black's Law Dictionary says police powers, the law of eminent domain in a state or political domain to enact laws for the common good and welfare, and to curb crime, and in great big black letters it says within constitutional limitations. See 10th Amendment. Do they have powers to take away rights guaranteed by the Constitution? Obviously, they don't. The 9th Amendment put a clear limit on that. 9. 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Due process. You have a right to due process of the law. If they don't give you due process, Title 5 U.S. Code Section 556 D is clear and specific and says if they deny you due process of the law, all jurisdiction ceases automatically. If they deny you due process at any time and you can prove it, you can force a showdown. You can say, well, they might have a jurisdiction at one time, Judge, but they lost it when they denied me due process. 6th Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, and to be informed of the nature and the cause of the action and accusation, to be confronted with the witnesses against him, to have compulsory process to obtain witnesses in your favor, and to have assistance of counsel in your defense. Or you can stand as your own counsel. You are the one who best knows your case. You are the best person to present the facts on your case, because you are the person who knows your case the best. 7th Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. The bottom line to this Constitution is that it's all in writing. It clearly represents a contract. I am asking you to learn your contract so that you can understand the rights you have under that Constitution. It is also important that you understand that this Constitution is supposed to be enforced. From A.M. Jerval. 16. Constitutional Law Section, Sec. 97. That a Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. See Note 31, Briers v. United States 273 U.S. 28. In other words, it is supposed to be liberally enforced in favor of the citizen for the protections of their rights and property. Any. 10. Constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. DeJammer v. Hoskell of Albany. This Constitution is a contract in writing enforceable in a court of law pursuant to the statute of frauds. I am asking for specific performance, Your Honor. In favor of me, I am the beneficiary of the contract. The contract shall be enforced most favorably in favor of the non-preparer, and that is you. If you truly believe that you have a right, and you timely bring that right before a proper adjudicated authority, and you can clearly stipulate what your right was, guess what? They have to listen. If you know your rights and you timely assert those rights, you have those rights. But if you sit on your haunches and you cry foul, you lose those rights. Argument 98, dealing with the effects of an emergency. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitution, Public emergencies, such as economic depression, they cannot be in conflict with the Constitution. The concept that an emergency could conflict the Constitution was rejected. In one case, the court holds that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of emergency, where the plain and unequivocal terms of the Constitution present two questions of construction and departures in emergencies. So even in emergencies justifies the taking away of constitutional rights. As to the construction with reference to the common law, an important canon of law is this: constitutions must be construed with reference to the common law. Since in most respects the federal and state constitutions did not repudiate, but shares the common law, this fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provision securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rules, that one charged with a crime may be convicted of a lesser offense necessarily included in the crime charged. In such cases, the courts of the state always regard the language in the common law sense. The common law prevails. The common law also permitted construction of the abatement of nuisances by summary proceedings. Traffic tickets, that is what a traffic ticket does. It is a writ of assessment, a bill of attainder. It is unlawful in the United States, and it was never supposed that a constitutional provision 11 was intended to interfere with this established principle. And although there is no common law of the United States in the sense, Erie Railroad v. Tompkins, in interpreting the constitutions of the United States, recourse still may be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal Constitution could not be understood. This is due to the fact that this instrument in the plan of government of the United States were founded on the common law as established in England at the time of the Revolution. Therefore, it is the general rule that the phrases in the Bill of Rights taken from the common law must be construed in reference to the latter. Specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment and the Fifth Amendment provisions relating. So the common law is extremely important. Most of you out there are citizens at the common law. Amjur 16. Sec 114, 117. Various facts and circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear, and unambiguous. In such a case, the court must apply the terms of the Constitution as written. They are not at liberty to search for meanings beyond the instrument. Amjur 16, Sec 165. Since the Constitution is intended for the observance of the judiciary as well as other parts of government, and the judges are sworn to support its provisions, sworn. As in oath of office, the courts are not at liberty to overlook or disregard its commands or countenance evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution, and to obey all constitutional provisions irrespective to their opinion of the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus is said that the courts should be in our alert to enforce the provisions of the United States Constitution, and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined, and must be performed in accordance with the delivery of judgment of the tribunal, before which the validity of the enactment is directly drawn into question. If the Constitution prescribes one rule, and the statute another in a different rule, it is the duty of the court to declare that the Constitution and not the statute governs in cases before them for judgment. They are telling the judge, you have got to rule in favor of the Constitution, asking the judge to do his duty under his sworn oath of office and uphold the United States Constitution as he swore he would under Article XXXX, Paragraph XXX. Look up for your state in this state, which says that he shall swear to protect and defend the Constitution from all enemies foreign and domestic, and he will perform his duties to the best of his abilities, so help him God. 12. Jur. 2nd Sec. 177 Declaratory Judgments. Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgments Act makes specific provisions of the determination of construction or validity of statutes or municipal ordinance by declaratory judgment and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statute and of ordinances. The Federal Declaratory Judgment Act has been invoked frequently as a means of assaying the constitution of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. A court may grant declaratory relief unless there is a case in controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the education. You have a right to demand a declaratory judgment. 16 Jur. Sec. 255. In all instances when the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. The court is without authority to declare a statute unconstitutional unless it is in positive or in direct conflict with the statutes or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconstant with the Constitution that it cannot be enforced without a violation thereof, because that would be violating the Constitution. Marbury v. Madison. A clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle, of course, is in line with the rule that doubts in the constitutionality should be resolved in favor of the constitutionality and the beneficiary. Jur. 256. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is reality no law, but is wholly void and ineffective for any purpose. Since unconstitutionality dates from the time of the enactment, not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves a question that it purports to settle, just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary since an unconstitutional law is void. The general principle follows that it imposes no duties, confers no rights, creates no office, bestows no power or 13. Authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. Where a clause repealing a prior law is inserted in the act, which act in unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. The general principle stated above applies to the Constitution, as well as the laws of the several states insofar as they are repugnant to the Constitution and the laws of the United States. Moreover, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had in its express terms been enacted in conflict therewith. Anything passed in conflict with the Constitution is clearly unconstitutional. Jur. 257. The actual existence of a statute prior to the determination that it is unconstitutional is an operative fact, and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested of status of prior determinations deemed to have finality, and acted upon accordingly and of public policy in the light of the nature, both of the statutes and of its previous application demand examination. It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. It would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. Jur 258. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution, which is in conflict with the Constitution of the United States. Jur 260. Although it is manifest that an unconstitutional provision in the statute is not cured because it's included in the same act with valid provisions, and that there are no degrees of constitutionality, so that an act is either constitutional or it is unconstitutional. So if you have a statute that is partly constitutional and